Georgia lawyers Bob and Irreverent D talk law. Listen up for stories about how things really happen in our legal system. Who are these guys? Dwayne Singleton, Irreverent D, is a criminal defense attorney in the state of Georgia. Benjamin O. Benson, aka Bob, is a personal injury attorney in Atlanta. On today's episode, Irreverent D promises to be a good boy.
This is sparkling water.
Yeah.
So my mom knows it's not alcoholic. Mom.
Bob gets discombobulated.
I want something to be right, but I can't. Now I can't. I lost it. It's gone.
And our guest Adam admits his shortcomings.
I am also the one guy in the room that doesn't have a beard.
Right. You should catch up.
Now, sit back and take a listen as Bob and Irreverent D talk law.
So I'm holding this $1,500.
It's been a year.
Well, it doesn't matter because it's an ERISA lien, right? So the right, it's not a hospital
You still don't
lien.
have to foreclose on the 1 year lien foreclosure statute. Doesn't apply even if it's ERISA.
No, that's specific to the other thing. But
Okay.
so that's not the story. The story is I'm telling the people who want me to pay money to them instead of to my client. I tell them, okay, we'll prove that you have an absolute right of reimbursement.
Yeah.
And they say, well, we're ERISA. And I say, okay, great, that's nice. You put a label on yourself. Show me the document that shows that you're ERISA. Mm-hmm. So they send me the booklet that says we have an absolute right of recovery, blah, 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 blah. And so,
Under
okay,
ERISA.
Yeah, under
The
ERISA.
booklet they wrote.
The booklet they wrote. And so then I say, okay, show me the document that shows that you're self-funded.
Because we said so.
The whatever.
The $5,500 they file with the IRS that they're required to. If they're
That you're required to.
self-funded.
They don't do it. They don't send it to me. I just say, okay, look, you tell me you're this. I tell you, prove it to me. You say, it's because we say so. Yeah. I'm not going to give you my client's money just because you say so. Like, you need to, and it's aggravating because, like, to me, I don't have a dog in the fight. It's my client's money. I'm not going to earn anything.
And
more,
unfortunately, I don't think the law puts a time limit on them.
No.
Right? Yeah.
No.
So,
Yeah. And so at some point, I finally said, look, I'm tired of playing games about this. If you don't show me a document that proves that you're self-funded, within 10 days, I'm just going to release this money to my client. Sorry, I don't know what to tell you. What else to tell you? And they just send me the same
Booklet
email
again?
over.
Yeah.
They send me the same email saying you need to immediately pay us. I'm like,
And you send them a
"Screw you."
copy of the check that you wrote out to your client with the money in it, right?
I haven't yet, but we'll see. We'll see what happens.
Sure. I got a question in the back.
What's ERISA?
The Employee Retirement Income Savings Act.
Yeah, and why is that important?
Like 1984 or something crazy.
It's important in that when somebody has health insurance through an employer where it's self-funded, where it's not backed by an insurance company, where they pay out medical benefits out of a pool of money that's collected from premiums charged to employees, they're governed by a different set of laws than other types of health plans. So in order for your health insurance company to get the money back for the benefits they paid for you, they have to prove that the amount you received from the third party, the person that injured you, puts you back into the same position you were in before you got hurt. They got to show you were completely compensated, which is almost impossible to prove to somebody that's hurt, unless it's a verdict.
Unless it's an ERISA policy.
Yeah. If it's an ERISA policy, that's governed by federal law, which preempts that state made whole complete compensation doctrine.
That's why it's important.
Yeah. And to be noted, it's not like you're ripping off your health insurance company because you pay them premiums every single month to pay your bills if you get hurt.
That's what you have it for.
So, these ERISA plans, you pay them, however many hundreds of dollars a month for your health plan.
Right.
And then you get hurt and they pay your benefits, they pay your medical bills, you recover from the third party, and then you got to pay them back all the money for your medical bills in addition to all those premiums you've paid them, over the years or months or however long.
Now, do you deal with a lot of subrogation issues?
Almost every case.
Okay.
Yeah. It's different.
Everybody wants money.
Yeah, state employees are covered by the state health benefit plan. If you work for like Delta or Lockheed or Home Depot, it's generally going to be an ERISA plan because there's so many employees to pool that money.
Now, what is subrogation, just for...
So subrogation is basically where somebody says, you got hurt by a third party, we paid your medical benefits for you, you recovered from that third party, so we want our money back.
Who's the third party?
The third party being the person that hurt you.
Okay.
So Jane Doe rear ends you and hurts you. You make a claim against her insurance company. You recover from her insurance company. Your health insurance wants their money back. That's the subrogation.
Because your health insurance company paid for the same medicals.
Yes, yeah. Same applies where if you have med pay through your insurance company and your med pay pays your medical bills, they want their money back through subrogation. They'll never get it. They're definitely subject to made whole unless it's like a Florida PIP policy or something like that.
So you're
Then
telling
it's
me
a
at the
little
end
bit
of
sole
my case, if we settle it
Yes.
and we agree to an amount, and they send the check, there's still stuff you got to do before you can give the checks out?
Almost half the stuff we have to do is dealing with making sure people get paid.
You have to have those conversations with your clients a lot, explaining to them.
So you always want to have that conversation with your client before you start the settlement negotiations.
Okay.
You got to say, look, they're going to give us a number, and that's not the number that goes in your pocket. That's the number that's got to feed all the different people.
So it's not like the commercial where they call us, I just settled it for $500,000.
No.
You got to explain like where the money's going to go.
Unfortunately, a lot of the advertisements in our industry kind of make it look a lot more glorious than it is when it's
simple.
all said
It's
and considered.
complicated.
It is.
We actually start that conversation. Yeah, I'm sure you do too. But like we start that conversation from the very first conversation.
Yes.
We talk about, okay, our job is to have your case completed, and that means getting money from all of the places we can get money from, and then paying all the people that have to be paid.
Yeah.
You, me, your doctors, the insurance company, anybody who's got a claim, anybody who has a stake, we call them stakeholders.
Yeah, personal injury claims, they're complicated. And we haven't even got into people who pay for like short-term disability benefits, things like that. That's a whole nother can of worms.
What about the client that says, I just want all the money. I don't want you to pay any of these people.
We can't. There are there are rules out there from the state bar. There aren't really. I don't think there's any actual statutes to the effect. But the state bar knows that if the lawyer is aware of somebody else who has a financial interest in the settlement of a case, we have an affirmative duty to take care of that for them.
There are attorneys who have been disbarred for failing to take into consideration the rights that other people have on the money that they got for their clients.
Yeah.
So what those decisions often say is that when we get the settlement, we essentially, as the lawyers, turn into a trustee of the money that we're given for the client's damages, and then we have a duty to anyone who has a claim on that trust amount.
Yeah, and where it gets really complicated is where somebody has, say, $100,000 worth of medical bills. There's a hospital lien. There could be ERISA governed subrogation, and there's only $25,000 in insurance coverage. And then you got to put the puzzle together with all these different pieces, and usually the puzzle's a lot bigger than the amount of pieces.
And what is a lien?
So a lien is, Georgia has a hospital lien statute, not just hospitals, could be physicians' practices. There's a variety of different entities that are covered by the statute where they can go to the courthouse and file a lien, not against the claim, not against the person who got hurt, but against their claim against the insurance company.
Right, because their claim is a property interest.
Yeah.
So it would be similar to Dwayne. You've got this guy who comes and works at your house and he does your roof.
Right.
And then you say, screw you, I'm not going to pay your fee, and they file a lien on your house. That means you cannot sell your house until you handle that mechanic's lien. Is that the mechanic's lien?
In like a hospital lien, you can't settle and disperse. You can't receive money from your settlement until you take care of that hospital.
Right. You may not pay them all of what they want, but you have to, as the lawyer, you have to deal with it.
So you're not just holding on to the client's money. You have to take care of these things. Right?
We get disbarred if we don't handle it right.
Yeah.
That's right. Okay, so we've been, I don't know how long we've been rolling since, but we've been talking, and it was so compelling, I didn't want to stop.
I had questions.
That and people, a lot of people just don't understand, like they don't know how complicated it is. Anyways,
and they don't need to. That's why they hire us. You know, I mean, we do this day in and day out. You know, let us explain it to them.
Yeah, it is, but you know, what you don't want at the end of the day is an unhappy former client that doesn't understand, you know, all the people that you had to pay. But this is Adam Taylor. Adam Taylor is our guest today. He is personal injury lawyer extraordinaire. We've tried cases together.
Extraordinaire might be a little bit of a stretch, but I am personal injury lawyer.
Everyone welcome Adam Taylor, personal injury law extraordinaire guy.
I am also the one guy in the room that doesn't have a beard.
Right. Should catch up.
I know, I should. I shaved this morning, not realizing.
Not realizing you're out of...
Yeah, everybody's got
Everybody's got the beard.
Yeah.
Means you're from a warrior class. It's good for taking a punch to the jaw.
All right.
Exactly. All right, so the news item we're gonna cover today.
And now, the news.
Today we're going to talk about this $118 million verdict in Bibb County.
That's a big one for Bibb County.
It says sets the record in negligence case involving this negligence case involved a man with disabilities. So here are the bullet points. First of all, for those of you who don't know, what's Bibb County?
Macon, Georgia.
Right, Macon.
It's the fairly favorable venue, I think. It's
for you.
Yeah. From a plaintiff's perspective.
Hour south of Atlanta,
Yeah.
down 75.
Yeah.
Right, Macon, Georgia, Bibb County. So it says that this man, who's severely disabled, mentally disabled, he was with a company who was taking care of him, like a day care type place.
Sure.
And it says that they were that the people who were working for this company were abused this man, including hitting him, beating him, saying nasty things to him. There was a video that was introduced in trial, video recording that showed that this plaintiff, this mentally disabled man, was struck 69 times by employees. Ooh, Good Lord, including being hit with a belt, punched, and slapped, according to the court documents. So there was a $118 million verdict.
It's one of those that makes your stomach hurt.
Yeah.
It does.
That's a case the insurance company probably should have settled. They probably shouldn't have let that go to trial.
That does seem like that's a lot. One of the things what we're going to be talking about in a future episode is tort reform. They were talking about nuclear verdicts. Would this kind of fall into the nuclear verdict kind of description that the
I think it would.
defense attorneys that complain about? There's another part of this that I wanted to point out, and that says, according to the plaintiff's attorneys, that there was a punitive damages phase. And before we get into the details of that, what is a punitive damages phase, Adam?
So punitive damages are, when I explain them to clients, I refer to them as punishment damages. They're not to compensate an injured party for the damages that they've had. Those are called compensatory damages. Punitive damages are to punish the defendant for willful, wanton acts, like for just acting intentionally or maliciously.
So this is it just wasn't an accident.
No.
I did something
on
purpose.
Yes.
Knew what I was doing.
Yeah.
And so this is over and beyond what your hospital bills and stuff like that.
And it's not just meant to punish that defendant, but it's meant to deter that kind of behavior from happening in the future.
What does deter mean?
To prevent it.
Keep other people from doing it?
Yeah, so if I own a daycare company and I'm giving my employees carte blanche authority to beat mentally disabled people, I might read that article and say, well, maybe I should stop that practice.
Maybe I'm not to do that.
So my understanding is that they were beating him with the permission of the superiors.
Wow.
Or at least there's consent.
There were emails that said, do what you need to do, just don't hurt the furniture.
Wow.
I think. I mean, I'm not sure.
No, that's what the article does say.
Yeah.
No.
So I'm the owner of the company, and I'm thinking, well, it's really too expensive for me to get training in here. And then I read this verdict for $118 million, and I think,
you may reconsider.
Maybe I should do better on training people.
Yeah, and that's the point of punitive damages. And I'm probably certain that the punitive aspect probably is a majority of that verdict.
So what it says is that the jury awarded $28 million in compensatory damages and $90 million in punitive damages.
Yeah.
So what makes this so high of a verdict? Why do you think it ends up like this at $118 million instead of $10 million, which is still a lot of money, right?
So one of the things that really drives these big verdicts, or what the defense calls nuclear verdicts, is emotion, and the primary emotion being anger. Okay, you can make a jury sympathetic to your client, but you're not going to get these big. What is this? Nine figures? What is it? 9 figures?
118. I can't do that high of math.
You're not going to get a 9-figure verdict from sympathy, but you will from anger. So, when you have a set of facts like this, where he's a
'Cause you're sending a message,
mentally
right?
disabled guy being he hit 69 times, something like that.
At least in one of the videos.
Yeah, and management doesn't do anything about it. That'll
set people off.
That'll anger a jury,
Right.
and that's where I challenge the defense industry to bring forth one of these nuclear verdicts that wasn't
something
deserving.
like this.
I mean,
Yeah,
because it sounds
show-
like to me the jury got it right,
Yeah,
right? They
show me
looked
a
at it-
joke case that ended up in a 9-figure verdict.
Right.
They won't. And these are situations where I'm pretty sure I don't know who the attorney is.
Yeah, I was gonna give a shout out to these
Yeah.
attorneys, C. Brian Jarrett. I don't know Gerard. And Charles E. Cox Jr. I don't know him either, but I mean,
Good work, guys.
Yeah, what an excellent.
But I'm sure they gave the insurer for this place an opportunity to settle the case.
Right.
Every plaintiff's a lawyer. When they get the insurance information, they find out how much coverage is available, will send what's called a demand letter for that amount. And in order to recover beyond that amount, you have to give the insurer a chance to settle.
Right.
And they probably just blew it. They probably didn't blow it off. A lot of insurers nowadays, they're using AI and they're using these algorithms, and they fill out all these boxes.
computer says this
and
is
the
what the case is
And the
worth.
computer says offer them X amount.
Right.
Only go up to Y amount. And those algorithms and programs, they can't account for emotion, and they can't account for what these jurors are going to be feeling when they hear these facts and they go back into the jury room and they deliberate over it.
What I often tell my clients is that when you really are contemplating, when you're thinking about going to trial, every trial comes down to some kind of gamble.
Yeah.
Right, and that's just from an outsider's perspective on this one, there's probably that thing going on, like there's a gamble on both sides. Like the plaintiff's attorneys are gambling that a jury of 12 strangers who don't know this guy are going to get super, super pissed off and award a big verdict. And the other side is gambling that, hey, it's not going to be that big of a deal. These guys are asking for more money than we think a jury's going to.
Yeah.
Because you can end up with a defense verdict, right? You can end up where the defense wins and you get zero.
Get
right?
bupkis.
Yeah.
That's right. If you haven't figured out how you can get that, you haven't done enough figuring. It can happen.
Me and Ben tried a case together where we brainstormed how are we going to lose this case, and we thought.
We did not think of.
And then we went to trial and we lost the case.
Don't put that out in the universe. Don't put that out there.
Yeah, we don't lose often, but that one, I always say to everybody, you learn more losing than you do winning.
Right.
That's right.
It's that was definitely a lesson.
Right. So I want to take the second part of this is a different case where someone died.
Okay.
Right. So we're not talking
So
about
one's
somebody
beaten,
who's
this one's died.
Yes.
So, right. So this is in a different case, and this is not a jury verdict. It's a settlement.
Okay.
All right. So
So here we probably have a situation where the lawyer sent that demand letter
Okay. That's
for the amount of the insurance, and the insurance company looked at it and they said, we should pay this.
we don't want to gamble with that.
We don't want $100 million verdict, so we're going to pay out the however many million, whatever.
And that's kind of what you and I bet. Speaking of gambling, we bet on that. That's our bread and butter, is knowing kind of where that line is, where an insurance company is going to say, we're not going to gamble with that.
Yeah.
Right. We need to pay that.
Sure.
And so in this case, what happened is that a woman who was in a wheelchair was in a vehicle, so she was in a non-emergency medical transport vehicle.
Oh.
So it's like being in an ambulance, but not in an ambulance,
Sure.
not emergency. And she was being transported to a doctor's appointment, and there was another person who hit that vehicle, and that van that she was in flipped over, and she was ejected and killed.
Wow.
So it was really terrible, and the crux of that case was, should she have been strapped in, or should she have been her wheelchair been secured? Should there have been more things to keep her from getting flown out?
She
of the
wasn't
vehicle?
buckled.
She was not. Well, I can't remember exactly what the detail was, but she was ejected from it, and the argument was she should have been more secured.
So shouldn't a death be worth more than somebody that lives?
Right. That's the big question. There's somebody
Well,
who gets physically abused, and there's a $118 million verdict, and then you've got somebody who dies, and there's only 3.1 million. What gives?
Well, so the 3.1 million, that's not necessarily jury verdict value.
Okay.
That's what the settlement was. That was
So
probably
that's what
the
they
extent.
worked out between them and the insurance company.
And that's is that Mike Raffey?
Yeah, Mike Raffey and Stockmeyer?
Yeah. I mean, Raffey's capable of taking a case to trial and getting a 9-figure verdict. I mean, he's got a good body of work under him. And he probably, when he sent the demand letter, I'm assuming that it's 3.1 million. So the van probably had 3 million.
That's right.
She probably had $100,000 in UM, or the person that hit the van probably had 100,000.
Right. There was a $100,000 USAA policy.
Yeah.
I've got a couple questions about this.
So when you go to trial,
Well, that
and
was
you got a $118 million verdict, but there's only $3,100,000 in insurance.
Sure. You can, well, first off, the injured party doesn't necessarily hold that claim. The insured holds that claim, and they have what's called a bad faith case against the insurance company for not settling the
For
case.
not paying out that policy.
Yeah, so let's play that out a little bit.
Sure.
Let's pretend that Rafi sends this demand for $3 million to the defendants and company, or their insurance company.
The vans.
The van,
Sure.
right? The van that should have secured her, as he says, and they contested that. So I mean, that's not an established fact. And the insurance company says, double-barrel middle finger, we're not paying that, right?
We'll take our chances at trial.
Deuces.
We'll take
Right.
our chances. We'll take our
Yeah.
chances at trial. This is
Which is the usual posture.
well, yeah, it can be. So then, the insurance company had the opportunity to protect their insured, the van company.
Sure.
And they didn't. They said, double barrel middle finger, we'll see you in trial. And Rafi goes and he gets a $118 million verdict
Sure.
against them because the jury got good and pissed off.
Sure.
Then, does the insurance company still just on the hook for the $3 million policy?
Yes and no. Lawyer answer. It depends.
Right.
Okay. So,
Can I just get a straight answer from you?
Sure.
Please.
So Rafi sends demand for $3 million. Insurance says, we think we can beat this at trial. We're not going to pay the demand.
Right.
They go to trial, $118 million verdict. The insurance company is on the hook for that $3 million. Okay.
Right.
Van company is on the hook for $115 million.
Right.
So that insurance company.
We're talking hypothetical.
Hypothetical.
Yeah, right.
That insurance company, when they got that $3 million demand, they had a choice. They could either pay it, the $3 million, or they could go to trial and gamble with the assets of their insured, who is the van company.
Right.
And
And
gamble it with somebody else's money,
Exactly.
right.
So-
In fact, our courts use that very word. They're gambling with that.
Yeah.
That's right. Go ahead.
So in order to deter this kind of behavior from insurance companies, we have what are called insurance bad faith laws. And after that verdict comes down, the insurance company still only has to pay the $3 million. However, the van company can then sue the insurance company to pay the remainder of that judgment or that verdict.
Right, because Rafi would have the rest of the 115 against the van
against
company,
van
right?
companies.
Right.
But the van company can either sue their insurance company to recoup that difference, or they can assign their claim to Rafi's client.
Okay.
And the client can pursue the remainder of the funds. Because the insurance company had a chance to settle. They said, no, we're going to gamble. And then it's to their insured's detriment that they did it. And so the insured has a claim against
So the attorney sends out the letter, for settlement letter,
Sure.
and then the insurance company doesn't settle immediately. That's not necessarily a bad thing in some cases. It could actually end up being a good thing.
I mean, for your client,
Right.
For the injured party.
depends on
yeah.
depends on what your client needs.
Right.
Yeah.
Right.
It's just it's bad. Our insurance bad faith laws are just incentive for insurance companies to do the right thing and protect their insureds. You have car insurance so that if you act negligently and you cause a wreck, that your house and your assets and your livelihood's not at stake.
Right.
That somebody will cover you.
But
Right.
if everybody did the right thing, wouldn't we all be out of a job?
Yeah, man. Yeah, I would probably be.
I shouldn't. I wasn't supposed to laugh that loud about that.
Yeah.
Yes.
If insurance companies just paid claims, so why would we be out of job?
Yeah, I was thinking about that this morning as I was thinking about our episode.
Sure.
Like, one of the things that our clients are often grumble rightly about, I guess, is that well, I got injured. Let's just say it's not one of these huge cases.
Sure.
Right? I got rear-ended, and the other person that hit me, they have State Farm or they have ABC Insurance. Sorry, not State Farm. We're not supposed to use real names, right? They have ABC Insurance, auto
Is the
insurance
episode brought
company.
to you by State Farm?
They have ABC Insurance.
Yeah.
I just want to send my medical bills to ABC Insurance Company, have them pay that as I go along, right? Our clients often want to hear us say that's okay, but that's not how it works.
Not in Georgia. No,
Not in Georgia.
no.
Why is that?
Because generally when these PI, personal injury settlements come from the insurance company, it's a lump sum at the end of everything. They're not. It's a little different if you have MedPay or Georgia.
But that's your insurance, though, right?
Yeah, it's your
That's
insurance.
right.
Yeah. Usually, if you don't have insurance, then there needs to be arrangements made with your lawyer in order to get you some medical treatment if you
Right.
need it, or if you have health insurance will pay it. And then when it's all said and done, there'll be a lump sum at the end of the claim, and that's what you pay the bills out.
But I don't want my health insurance to pay it
you
because
do.
it's
That's
somebody
not right.
else's fault.
It's not
I don't
right.
want it to come out of my
Yeah.
insurance. Do I have to do that?
You should, yes. There's some lawyers who may advise differently,
Right.
And it's my position that's not the best advice. I think you're in a much better position if you can get the health insurance that you pay every month for, that you negotiate or your employer negotiate a contract with. You want
Right.
them to
It goes
be
back to that
excellent.
fancy subrogation word we
Then
talked
you deal
about.
with the subrogation, and it's in your health insurance. They have contracted rates with every medical provider. They pay a certain amount
Right.
per coding, per code, and you'll benefit.
You get the
better in
write-off,
long run.
right?
Yeah, you'll benefit in the long run from it.
The other part of that is that in our system, the normal course of things, let's just say it's not a personal injury case.
Sure.
It's a contract case. You were supposed to do work on my basement. You screwed my basement up. The normal course of things is I get another contractor to do the work to fix your mess up, and then I take you to court and I show the judge or the jury, this is what it cost me to fix, right? The law does not like us to go into court and say, this is the estimate for what it's supposed to cost to fix.
The legal word is speculation.
Speculation,
No,
right?
nobody
Because
likes conjecture.
Right, because how many times have we gotten an estimate for something
Yeah.
and it never comports
But I
with
don't want to
reality?
have the surgery. Just give me the money for the surgery.
Oh God,
Yeah,
that's a whole nother episode.
Yeah, we could run a few episodes on how to handle that.
But that's true. I have a surgical. I've always struggled with that, Adam.
Yeah.
I have a surgical case. I have a surgical back. I need a backiotomy or whatever, right?
A back replacement.
A back replacement. I need a back replacement.
Yeah.
I think it was from a Dave Chappelle episode one time. I need a backiotomy, right? Shouldn't the insurance company be paying as if I have this
Would
back
be nice.
surgery?
Yeah.
Versus, but if I'm not going to have it, they're not going to look at that as my damages.
Yeah, that's true.
Yeah,
That's generally
that's
how it
always
runs
a
course.
struggle.
Yeah.
Yeah. So I want to finish with just this kind of general idea that one of the themes that goes through these stories is that your damages is only one part of the whole picture. When we're building our case for our clients, we're thinking of all three parts of the picture, and that is like, one, can we prove the other person's at fault?
Yeah.
Two, how much are your damages? How bad are you hurt? And three, how much coverage is there? Because if you're really super hurt bad, and it was really super somebody else's fault, but there's only $25,000 in coverage, there's only $25,000 around there.
Yeah, you're limited there. Unless
Right.
they blow a demand,
Right,
like
right.
we
You
just
could-
talked about with bad faith.
There are exceptions.
Is that what you call it? Blow a demand?
Oh, yeah, when they blow a demand.
I
When
like
you
that.
send them a demand letter and you're like, here's a gift you can get out for $25,000, and they don't.
Right.
That's called bond. And one of the things that I like to focus on, I think a lot of PI injury lawyers focus on the damages aspect of a case, and damages are important. It's important to build your damages case and get good deposition testimony from treating physicians. But I really like to hone in on defendant's conduct.
Right.
That's the kind of stuff like that $118 million
makes people
verdict.
mad.
That's
Yeah.
the kind of stuff that can Damages, that'll invoke sympathy from a jury, but focusing in and honing in on the defendant's conduct, that's what'll get them angry, and that's really what can drive some bigger verdicts.
And I think that's why you see the value of a case sometimes changes from one attorney to another about how they handle the case, how they look at it, how they evaluate it.
And that's I find it especially true in truck cases, not necessarily truck cases, but commercial vehicle cases where there are commercial vehicles, they're governed by a whole set of regulations that you and I, as civilian drivers, don't have to deal with. And when you end up litigating a trucking case, you get such an amount of information. You get so much more information. If you sue Jane Doe, who rear-ends your client on her way home from work,
in her 2002 Honda Civic.
What do you get? An MVR of 7 years of driving record. I mean, with the trucking case, man, you get driver's daily logs. You find out where they've been. How long they've been driving. The hiring process. You get employment file. I mean, you can really dig down deep into those cases.
And that's what we were talking about earlier before the show started, was about sometimes you don't know until you dig into a case.
That's
you were
right.
telling us about that boat case.
Yeah, the Malibu boat case.
That was fascinating.
Yeah, Drew Ashby, a lawyer here in Cobb County, tried a case up in Rayburn County against the Malibu boat, the boat manufacturer, where there was a time where I don't really know the finer details of the engineering of boats, but where the front end of a boat was capped. And one of Malibu's competitors, I think, took the cap off and put some seats in it, and it was big with the consumers.
Made it a party boat.
Yeah, made it a party boat.
Right.
And so Malibu followed suit by removing the cap. And they started to notice there was a problem where the boat would be porpoising, like when it was
Going underwater instead of on top.
Yeah,
of
when there was some wake, like going in and getting water in.
Right.
And the engineers sent executives notices saying, we have a safety issue here. The boats are taking on water. We need to redesign them. And I think
and they fixed it like they should supposed to.
Yeah.
They didn't fix it?
One of the things that came out in trial, and this is another thing about digging down deep, Drew Ashby is fantastic at this. He doesn't handle very many cases, and those that he does, he really gets into them. And there are emails from the executives to the engineer, I think. I learned about this case months ago. But they said, to the effect of, maybe we should put stickers on the boats that say no fatties in the front. Or maybe we should just, put the kids in the front and fatties in the back.
That would not make me happy as a juror to see that.
And so up in Rayburn County, somebody was driving one of these Malibu boats, and it porpoised, and unfortunately it washed a child out, and he got caught up in the propeller and didn't make it. And Drew tried the case. It was a multi-week trial. I don't remember exactly how long. And it was a 9-figure verdict.
Wow.
Because he dug into a case. He focused on, the damages, that was there.
Right.
You have a deceased child.
Yeah.
And he focused in on the defendant's conduct and just how nonchalant the executives were about a safety issue. And they were dumb enough to put it in an email. It was kind of, if they had fixed it, the child would be alive,
Instead of making light of it.
Instead of making light of it.
Now it's time for
questions from a 10-year-old.
All
right, let's bring
questions from 10.
Let's bring 10-year-old in. All right, what is your question, 10-year-old?
Why do we ring the bell?
Ring it. Ring the bell. Why do we ring the bell?
Nice.
That came in episode 6, right?
I don't have a bell. Well,
I don't have a bell either.
But Ben's got a cool bell.
We got a ship bell in here, and we ring a bell every time that we get money for one of our clients, and that's to remind us.
All right.
That's to remind us. We're lawyers. I'm a lawyer. We're in the practice of law. But we're in the business of getting money for our clients.
It's the justice bell.
It's the
the justice.
I try.
Absurd,
I try not to use the J word.
Okay.
We don't. In fact, what I tell clients in my very first conversation with them, Adam, is, listen, I love you. I want there to be something right at the end of this, but understand, I don't do justice. I do money. Yeah. I do money for your damages. That's what we do. Like, we get money for your damages. Yeah.
I had a case last week where they're going to dismiss your case if you pay $300 in a pretrial diversion. Now I want to go to trial.
No, God.
These are felony charges that you'll do 10 years on. I just want justice to be served. I'm like, this is
gosh.
justice. It's going to go away. There'll be nothing on your record.
The other one that's a corollary to that.
You ring
do
the bell on that one. Man.
You ring the bell? Oh, right. Yeah, because in that
You need to ring the bell. We won.
Suddenly she's not here anymore.
Disappears.
Just like that.
Yeah.
Modern science. Thanks for coming on the show.
Thanks.
We
Thanks for
really
having me.
enjoyed
I
having
appreciate
this.
it.
This was a good episode.
Yeah, it's a good chat.
All right.
I enjoyed it.
That's it, folks.
All right. Thanks, Harris.
Thanks for listening. Tune in next time when Bob and Irreverent D talk law.